Assalamualaikum warahmatullahi wabarakatuh. Today, there is a young professor. His name is Dr. Rahaman. He is come from the Adjunct Professor. Oh, sorry. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone, to all the participants in here. Today, we have a class in Adjunct Professor, who is named Dr. Mizanur Rahaman. As we know that Dr. Mizanur, Associate Professor from the University America of Baghdad. Is it right?
Yeah,
American University of Baghdad from the Iraq. So she wants to share about international and domestic law in investment disputes. So to all the participants, especially in my class, have one question for our lecture. So focusing, dan buat yang kelas saya, tolong rangkum apa yang oke, itu yang jadi tugas saudara. Nanti kita akan lanjut lagi di Zoom itu pertemuannya. Ada beberapa yang sampaikan. So to all the participants from another class, please make a resume too. Yang kelasnya Bu Anissa juga buat resume nggak? Nah, okay, it's okay. So to especially for my class. Okay. I see. Wait. Bah, ini. Okay, you can shift, you can stand. Okay, yes, me. So we continue to our first. Before I forget, here's our senior. This is our senior, Professor Akmal. He's come from the Jindal. She is adjunct professor before Mizanur. There are two programs from the lecture in this semester, in this year. And the early year, he is a young professor, Mr. Akmal Handi Nasution, and the second is Mizanur. Okay. So she is the alumni in law faculty in 2000. What year? Yeah, in 2006. Is my senior. I'm until 2008. Jadi beliau adalah alumni kita di 2000. Beliau adalah tamu 2006. Dia sekarang home base-nya dosennya di Jindal, OP Jindal Law School di India. So dia juga adjunct professor dulunya sebelum Mizanur. Kita ada adjunct professor sebelumnya itu di kelas beliau, dan sekarang adalah kelas Mizanur. Spesialitinya investment ya, Bang ya? International economic law. Okay, shall we continue?
Yeah.
Okay.
Right. So today we are going to discuss about international and domestic law in investment disputes. Okay. So international investment law is a complex area of law. So it's not just one law that applies in investment disputes, but there are different legal frameworks that apply to international investment disputes. So whenever there is an investment dispute, then different laws come to apply together, and these laws are kind of connected. They're interrelated. So if you look into the legal frameworks or what laws apply to international investment disputes, then you will find 3 areas of law. One area of law is international, and that's why it's international investment law. Another area of law is a domestic or national law, okay? And to some extent also contract law contract. And law contract can be sometimes difficult to understand because it can be the national or domestic contract law, or it can be private international law, means contract laws which are general principles applicable at the international level, like the law of the sale of international sale of goods, those kind of laws. Okay. So first of all, I'll give you a brief idea because I just got to know that many of you are not familiar with international investment law or not yet studied international investment law. So first, I'll give you a brief kind of outline in the recent, trends and dynamics in the international investment, how investments are made, how investments are kind of moving across the globe, which countries are now making most of the investments, this kind of idea. So first of you see that I have kind of mentioned here mostly about China, because if you look into the recent dynamics of international investment, then you will find out it is China which is making most of the investments across the world, whether it's in Asia, Pacific, whether it's in Africa, or even Europe, and even the North America. So I have kind of mentioned here from 2005 to 2019, you see the billions, 815 billion or the Chinese investments are in construction projects. So as you can see, the amount of dollars China is investing in different continents. Okay. And out of that, you see, I have kind of gave a brief statistics here in terms of FDI, which is called foreign direct investment. Means a Chinese corporation or Chinese government-owned enterprises are making investments in directly in another country. So you can see that Indonesia is one of them, where 24.1 billion has been invested by Chinese government or Chinese corporations. When it comes to construction projects, and these are slightly different. Why I mentioned two: one is FDI, and another is a construction projects. They are slightly different, and I will come to that. Okay, you will see that how in Asia, top destinations in Asia, Singapore, Indonesia, Malaysia, these are the top destinations for Chinese investments, and mostly they're in the FDI and construction projects. Now, why these two? I have mentioned two different FDI as well as construction projects, because when it comes to FDI, one set of law becomes applicable. Okay, when it comes to construction projects, another set of law becomes applicable. So as I said, so I generally say, or authors, different authors have pointed out, there are three laws of international investment. So when it comes to investment disputes, you need to look into what laws become applicable, which laws are involved. So there are three laws, and these three laws will become involved in investment disputes. So whenever there's a dispute, we'll discuss some disputes, Indonesia and disputes regarding the government of Indonesia and some other foreign investors, like investors from India, investors from UK. We'll look into that. So before we go to that, you need to really understand what laws actually become applicable to those disputes. Because as a lawyer, you need to look into the law in terms of advising your clients, in terms of preparing a brief, for example, or probably even in terms of advising your clients, advising governments, government institutions. So you need to understand what exactly the laws that are involved, and then which area of law you need to study in detail so that you can advise properly. So basically, there are three laws of international investments. Now, when it comes to FDI, foreign direct investment, one set of law becomes applicable. Okay. When it construction projects, then another set of law becomes applicable because disputes arise, means investment disputes between government and in foreign investors arise because when either the host government means let's say Indonesia is a host government, means foreign investors are investing their money in Indonesia. So Indonesian government is the host country, host government. Okay? So host country government has certain expectations that, and when inviting investment in a country, the government expects something, some benefits, from the investor, how that investment is going to benefit the country or its people, or how that investment is going to contribute to the Indonesia's economy, okay? In terms of economic development, social development, so government expects a lot of expectations from the foreign investors, okay? The foreign investor who are investing their money in Indonesia, they also have expectations. Because if I do not get any profit or benefit, then why should I invest in your country? Because there are many countries in the world. I should invest, go to Malaysia, go to India, go to Vietnam. Why should I invest in Indonesia? So the host country or the government also needs to give benefits to the foreign investors. And those benefits can be very, very different. Let's say, take an example, giving concessions. Just to give one example. So Indonesian government can say that those foreign investors will invest in the country, in Indonesia, they will be exempted from taxes for the next 5 years. Okay? Means foreign investors will not pay any taxes in the next 5 years. So 5 years tax exemption. But as an Indonesian, you pay taxes, right? As a citizen of Indonesia, you have to pay tax on your income. Now you see the difference. The foreign investor is given more privilege than you. Okay, so because the Indonesian government thinks that foreign investor will contribute to the economy, it will ultimately benefit the country, its people, its citizens. Okay? In terms of more livelihood, more employment, more income for the government. However, in return, the government also needs to give something back. So giving a concession, let's say tax exemption for 5 years on foreign investors' income. Okay. Now, what happens is that when it comes to different types of projects, it can be FDI, it can be construction projects. The government simply saying that I will give you exemption for 5 years, tax exemption, is not enough. I can say something today, I can change my mind tomorrow, right? Tomorrow I can say, no, oh, that is another government, we are a new government, now you have to pay taxes. It can be like that. Political regime can change, government can change, new government can come into power and say, oh, that was the previous government. As a new government, we want to collect taxes from you, right? So that can happen, and it happens actually in practice, okay? That's why the disputes arise, okay? Now, what happens is that government enters into a contract with the foreign investor. And contract, as you know, is an agreement, right? And an agreement is a promise. So government enters into an agreement with a foreign investor that in return for your investment, we are going to give you 5 years tax exemption. That is a promise. Okay. So agreement, if the government, whether the existing government or the new government does not fulfill that promise, then the foreign investor brings a dispute, brings a claim that you actually breached your contract, breached your promise. And that's where the disputes arise. It can be different types of disputes, but I just gave you one example for understanding, okay? So most of the time, these disputes arise when there is a mismatch between host countries or host governments' expectations, responsibilities, obligations. At the same time, the foreign investors also have certain responsibilities, also have certain obligations. Okay, if they fail to fulfill their obligations, then the government, host country government, can also bring a claim against them. So let me give you another example. So I gave the tax exemption, example. Now, when the government is saying that we are going to give you a tax exemption for 5 years, the government can say, in return, let's say the foreign investor is a power company, means the foreign investor will invest in Indonesia and produce electricity, an electricity plant, electricity production plant. They will invest, they will develop the project, they will produce massive electricity, and they will sell that electricity to the Indonesian government. Okay, so the government said, okay, we are giving you exemption. However, in return, you will sell your electricity to the government at a subsidized rate, means at a lower rate for the next 5 years, because you are giving you tax exemption, so that the price of electricity remains very low. Indonesian citizen can afford to pay for the electricity. Okay, so that would be another agreement, contract. Okay, FDI in terms of Indonesia, what kind? So that depends, and I will come to that later. What types of contracts there are. So if the foreign investor fails to keep its promise, means selling the electricity to the Indonesian government at a lower rate, then Indonesian government can bring a claim against the company or foreign investor that you have failed your promise. Okay, so that's where the disputes arise, for the investment disputes. Now moving on, so I just give you a brief primer why disputes arise and why we are looking into international investment disputes. And when we look into investment disputes, what laws can be applicable? So as I say, whenever there is a contract between the government and foreign investor, it can be contract law. Okay, because it's a breach of contract, breach of promise. So contract law becomes applicable. Okay, but there are other laws, but I'll come to that later. So moving on, as you see that more and more investments are coming from China and they are made in Asia. Indonesia is one of them. Can we move on? Okay. Now, one of the interesting facts that probably many of you are familiar, or maybe you are not familiar. Some of you might be, some of you not read it. Now, as I just have shown you, that Malaysia is one of the countries where a large amount of Chinese investments are going because of the Chinese Belt and Road initiatives. In short, was a short called BRI project. So China is making huge investments according to its BRI projects. Now, recently, the former Prime Minister, a few years back, Mahathir Mohamad, was a Prime Minister of Malaysia, and he went to China in the Great Hall of Beijing. He said that a new vision of colonialism means that Chinese investments are to some extent a form of new colonialism. Means, according to him, that the Chinese investments are creating a form of dependency. Means these Asian countries like China, Malaysia, Indonesia, they are increasingly became dependent on foreign investor, or more specifically China. And he immediately standing there canceled a 2 to 23 billion rail project that no, we are canceling that project, no more. So dispute can arise that kind of cancellation. So when one government invited a foreign investor to invest in the country, the next government comes into power and cancels the project. Because as I said, foreign investor has expectations. They are expecting that they will make a lot of profit out of their investment, and suddenly a new government comes into power and cancels the project. So a dispute, the foreign investor can bring a dispute that, and for just for your information, a foreign investor can even bring a claim when the project has not yet started. Okay, because in international law, probably you have studied or maybe you heard a principle called legitimate expectations. So when someone is expecting something, and if that expectation does not happen, then there is a loss. So if you're interested, you can search on Google and look at it. So there was a dispute, investment dispute brought by a foreign investor against Pakistan. And the project never started. Obviously, the Pakistan government invited the foreign investor. They have agreed that they will make the investment, and in return, the Pakistani government will give certain benefits. They entered into agreements, number of agreements, but the foreign investor never made the investment, never started the project, because they blamed Pakistani government that there are different rules and regulations, permissions, which are not given by the government. However, the investment arbitration actually awarded the foreign investor $4 billion, even without making any investment, because the foreign investor was expecting that they will make the investment, they will make a profit out of it. And since the project never started, their legitimate expectation did not happen. They actually suffered a loss. They failed to make any profit out of the project. So the arbitral tribunal gave $4 billion of award to the foreign investor, even without making any investment. So cancellation, that type of cancellation can also lead to an investment disputes. Okay. Secondly, IMF, many of you heard the name International Monetary Fund, which an international organization, or you can say intergovernmental organization, which regulates a lot of aspects in the area of international investment law. I'll kind of briefly mention later also what is the role of the IMF. Now, they also recently pointed out that Sri Lanka, one of the largest recipient of Chinese investments, also kind of unable to repay its debt. Okay, so you can see that so when a host country fails to repay that debt, that can also lead to investment disputes, because repaying the debt is also lost profit. Okay, because when a foreign investor is making investment, it is expecting that the investment will be repaid, or investment has been made as a form of loan, and the loan will be repaid, and a foreign investor will kind of make a lot of profit out of the interest that has been paid to the loan. Okay, so when a country fails to repay the loan or the debt, that can lead to a loss of income, loss of profit, can lead to a investment disputes. Thirdly, Indonesia also recently canceled a 5.5 billion Jakarta-Bandung rail project. Okay, so you can see how increasingly the government, especially Asian country government, are canceling investment projects, or kind of denying some of the rights and obligations that are actually promised, but later kind of backed out, that ultimately thinking that it will create a kind of debt trap, because the investment is so large, and therefore the government might not be able to repay the loan or repay the debt, or might not be able to fulfill its obligations or promises under the project, under the agreement or contract, and therefore it is better to back out, because ultimately if the government fails, that will lead to a multi-billion-dollar investment disputes. Okay, and we will look into some of the disputes Indonesian government kind of recently faced and what happened to those disputes. Can we move on? Yeah. So I have kind of briefly provided here statistics before we go into more detail, the legal aspect, that you can see that, how investment disputes are continuously growing. Okay, so these are the statistics of ICSID, which is a short form of the International Center for State Investor Dispute Settlement. Is an international organization you can call, and it functions under the World Bank, which is obviously an intergovernmental organization. So is a kind of ICSID is a center where most of the investment disputes are settled. Okay, and you can see how year by year investment disputes are increasing, going up. So my point here is that as you see, the investments are growing. Chinese investments are growing in Asia. Other countries became the largest investor. At the same time, investment disputes are also growing. So more investments, more disputes. Okay? So as the investment climate grows, as countries are trying to attract, trying to make their country investor friendly. And in order to make the country investor friendly, governments are liberalizing the economy, liberalizing laws, changing laws, amending laws, okay, so that the country becomes more attractive to the foreign investors. They come to the country, they invest, make more and more investments. That is a good thing because the investment ultimately has benefits. Okay, it contributes to the economy, economic development, people's employment, more jobs, livelihood for the people. However, you also need to think about that with this growing investment climate, liberalizing the economy, liberalizing laws, changing laws, investment disputes are also increasing. And what is more interesting, you can see that side. I kind of focused on Asia rather than going to the other parts of Europe because it's probably more interesting for you to look into Asia, how investments, how countries became a complainant, respondent as third party. So here you see, if you look into Indonesia, has become in third party as well as respondent. So you can see all these countries are participating actively in investment disputes. But the picture is very different if you go back to 1994, 1992, you see very little. Small participation of developing countries, a small number of disputes. So you see the more the investment, more the involvement of states or governments into investment disputes, and the disputes are rising continuously. So international investment disputes is an area, is a continuously evolving area of law, and it's a complex area of law. So if you want to study investment law and kind of be more interested to study in detail, then it is a very interesting area of legal practice. Also, as a lawyer, you might be interested to kind of practice in the area of investment law because more foreign investors are coming to Indonesia and they need legal advice, they need legal expertise in the different areas of law. So you can think about that. You might become an investment lawyer to either helping the government shaping the law. In terms of helping the government in investment disputes, or you might want to advise foreign investors or clients in terms of framing their or making their contracts, drafting contracts, advising on corporate law, company law, all these areas. Here again, as I just said, that right now you can see that these disputes, investment disputes which are going on, the value of those disputes in total $86 billion. Now, interesting fact is that recently the trend has changed slightly, but before the trend was that most of these disputes were decided in favor of the foreign investors. Means that it is the foreign investors who are mainly making profit out of these investment disputes, because when it goes to arbitration, the decisions are mainly in favor of foreign investors. There's hardly any decision in favor of the government. Okay, so the value of this dispute, so you can say that dispute settlement has become a multi-billion-dollar industry. Okay, now one of the interesting fact is that many governments or many investors nowadays, because it's an expensive affair, because the disputes are generally settled by arbitration. And this dispute settlement through arbitration can be very expensive. So let's say many host governments are unable to bear the cost of, because a dispute settlement can cost $10 million or $15 million, $30 million, depends on how large the investment is, how complex the dispute is. Thus, simply settling in the proceeding, appointing the arbitrators, lawyers, it can cost a host government or a government, whether a state, a government, or a foreign investor, maybe $15 million, $30 million. Many countries cannot afford to, even to spend that amount of money just to settle the disputes. Okay? So what is interesting development in the area of investment is third-party funding. Means, so another funder, let's say I am not a party to the dispute. I'm simply a wealthy businessman or a bank. Okay? I want to fund the government. Okay? With the expectation that if the government wins, then I will get back my money in return, and also probably some favorable treatment from the government in terms of concessions, maybe other types of privileges, or I might say that I want a portion of the award, so that if the arbitral tribunal awards $1 billion, then I can say I want a 50% of that award money. So I invested 30 million, and also if my party wins, then I get the 50% of the award. So you can say dispute settlement has also become a kind of profit-making business. Investing in disputes. Okay, so that is a more complex. I'm just giving you a brief idea why these investment disputes are so important, so interesting, but they are also complex. So in order to understand, you also need to look into different areas of law to understand properly how they actually function. Move on. Okay, now some high-profile investments I I can give many examples from different countries, but I generally focused on Indonesia. One of the disputes Indonesian government was involved is the AMCO Asia Corporation and the Republic of Indonesia. It was an ICSID dispute settlement, as I said. ICSID is the International Center for Settlement of Investment Disputes. It is a kind of organ of the World Bank, means it functions under the World Bank. And as you know, World Bank is a kind of is an economic intergovernmental organization, but it is also an economic organization. Many call it a neoliberal economic institution that helps or that pushes countries to liberalize the economy, trade, borders, changing laws, amending laws in return for funding, in return for loans. So just to briefly make it clear. So World Bank is a world funder. Means it gives loan to different countries. Anyone can go to the World Bank and ask for a loan. Okay. Now, what the World Bank says is that, well, yes, I am willing to give you a loan, but in return, you have to do this. You have to reduce your public spending. You are spending too much on your health, on your healthcare. Reduce your spending. You are spending too much on education. Reduce the spending. And why it does that? Because if you spend too much for the public, then you have little money to repay the loan. Okay. So you should reduce your spending in different public public, benefits, public care, so that you have enough money to repay my loans. Okay. However, nowadays the World Bank does not do that because it came under huge criticism because of all these, we used to call it conditions. Okay, conditions for a loan, but nowadays the World Bank does not do it. Okay, so you can understand that World Bank as an economic institution, it pushes countries to liberalize, and ICSID is an organ of that neoliberal organization. So you can obviously understand what should be the approach of the ICSID. If World Bank is a neoliberal organization, pushes countries to liberalize, then an organ functioning under the World Bank will obviously have a neoliberal approach. And obviously that means that giving most of the awards in favor of the foreign investors, because that's the pro-business approach, right? Okay, so that is one of the why I mentioned this case is that I mentioned that the three legal frameworks. So as you can see here, that there is a contract between PT Wisma, okay, which was supposed to kind of manage and lease a hotel. So the contract was between PT Wisma and Amco Asia Corporation. Okay, so the Amco Asia Corporation made the investment, and they entered into a contract. So contract is a law, right? When you are entering into a contract, it is governed by one set of law. It can be national or domestic contract law. It can be, and it's a cross-border contract. It's international contract. It will be governed by private international law. And private international law slightly different than domestic contract law. But however, when it is a kind of unification of private law, therefore the general principles of contract law are almost similar. So that is one legal framework you find here: contract law, contractual framework. You can read the decision later. I will share the slides so you can read them more detailed, because I'm slightly moving faster because of time. Because I had just 1 hour, 1.5 hour. So I'll take 1 hour 15 minutes and 15 minutes for questions and all those things, because I'm moving on a little bit faster. Yeah. Another quite well-known interesting case is the Rafat Ali Rizvi and the Republic of Indonesia. It was a 2011 case, ICSID case. And again, you see here, the foreign investor invested in a bank, Century, in Indonesia. So again, when you are investing in a bank, you obviously enter into a contract. Because let's say if I am an investor, how does investment happens in a bank? Purchasing shares, right? Shareholding. I am investing in your bank and I will take shares. Okay, I'll purchase some of the shares from the company, because bank is a company. It can be a private bank, it can be a public bank, means a state bank, a state-owned or subsidiary, partially owned bank, depending on the structure of the company. It can be state-owned, completely state-owned, it can be private, it can be a joint venture, depends on the articles of association. If you have studied company law or corporate law, you understand how the business structure, a business or a company is created or established. That depends on the articles of association. Who has the majority share, who has the minority share? We call it majority shareholders, minority shareholders. So again, you see this Rafat Ali Rizvi, he kind of became an investor in the bank through a subsidiary company called Chinkara Capital Limited. Okay, so again, it's an agreement. However, it's not just a simple agreement, also a shareholders agreement, because in return, the company also owned or became the owner of certain amount of shares. Okay, so that is again, so what you see here, contract law as well as corporate law, company law, right? Yeah. Yeah, no problem.
So ya, saya speak in Indonesia for a bit. So jadi perkara Rafat Ali Rizvi Itu perkara Bank Senturi tahun waktu Pak SBY jilid 2. Ada yang ingat? Ada yang pernah baca perkara Senturi? Yang masalah bailout, yang masalah dana talangan? Nggak ada yang tahu? Jadi saksi ahli untuk pemerintah Indonesia di perkara Bank Senturi ini di exit itu Prof Ningrum. Jadi Prof Ningrum datang ke sidang, jadi dia jadi saksi ahli untuk perkara ini mewakili pemerintah Indonesia. Jadi keterangan ahli dari Prof Ningrum itu salah satu keterangan ahli yang kunci yang dimana akhirnya Indonesia di situ menang, menyatakan kalau Rafat Al-Rizvi ini investasinya tidak sesuai dengan BIT dan undang-undang investasi. Nanti untuk secara sedikit lebih detailnya, Dr. Mizanur yang menjelaskan. Sama yang di belakang, tolong dikurangi suara karena ini teater. Jadi teater itu kalau kita ada bersuara di belakang, dia datang ke depan suara, jadi ganggu pembicara. Ya. Jadi ini nanti ada yang ngambil kuliah sama Prof Ningrum di sini.
Zoomnya dari mana? Dari kelas ada dikirim Zoomnya.
Oh ada ya?
Boleh.
Oke. Jadi ini jadi nanti salah satu mungkin bisa bahan diskusi tentang investasi dengan Prof Ningrum atau dengan Dr. Mizanur. Thank you, Dr.
Yeah. So you can see that I have kind of highlighted here majority shareholder. So that Rifat Al-Rijvi was the majority shareholder in the bank. So that's a share. When it comes to shareholding, the company law, the corporate law also become applicable. Okay. Now what happens is that the Indonesian government, the bank actually went through a debt, and the Indonesian government had to kind of bail out the bank. Repaying the debt and all those things. Now, the dispute was, as you can see, I have mentioned 1976 UK-Indonesia BIT. Okay. Now, BIT, B-I-T, in short, and in the full form, it is called Bilateral Investment Treaties. Okay. Bilateral Investment Treaties. Now, these are treaties, and I hope if you little bit, think about international law, treaties are also agreement. Okay. But agreements between two countries, not between two private parties, or not a contract between a government or a private company or a foreign investor. Treaties are agreements between governments, between states. And if you think about the Vienna Convention of the Law of Treaties, which talks about treaties can only be between two sovereign governments. Now, here you can see the interesting thing is that BITS, which is a treaty, means an agreement, international law. Treaties are a source of international law. If you little bit think about what are the sources of international law, treaties, conventions, protocols, right? According to Article 38(1) of the ICJ, a statute of the ICJ, International Court of Justice, okay? So treaties are one of the sources of international law. So treaties are international law. So you can see here, one becomes contract, shareholders agreement, contract, then shareholding, how much share should be who owns which share in terms of voting, all those things, corporate law, company law, then BITS, international law. So you see contractual law, contract law, company law, domestic law, national law, international law, treaties, BITS. So you can see here how these three laws of international investment, how they come together. Okay, but they are also linked. So what is interesting about this kind of disputes is that a dispute arising because of a contract. A contract between Rafat Al-Rijvi and Century Bank. Contract law, which is what you call it. In civil law countries, in Indonesia, civil law country, you call it private law and public law, right? Private law, contract is a private law. Corporate law, company is a private law, right? Now, the dispute, the agreement between this foreign investor and a Indonesian company is a matter of private law, contract, corporate law, right? But the dispute, the claimant means Rifat Ali Rijvi, made the claim under BITS, under international law. Do you get my point? International law means public international law, because treaties are sources of international, that is public international law, right? So you can see how these three legal frameworks, private and public. And that's why we saw, we sometimes, there's a debate in the area of investment law, whether international investment law is a private law or is it public law. Some scholars argue that international investment law is actually a public law, public international law. Some argue, no, it is not public law, it is private law. Okay, so there's a dispute, there's an argument, all the debate, all these things happens. Okay, so one very very well-known scholar in the area of international investment called Gaz van Houten, he wrote a book called International Investment Law as Public Law. That is the title of his book. Okay, so so there's a debate that how the question arises: how can a dispute that arises from private law, domestic private law, contract law, corporate law, goes into international law when the claim arises, right? Now the interesting fact is that the treaties, these BITs, are private. I mean, between two countries, two governments. However, these kind of treaties are entered between two governments to protect, to kind of give privileges or to give benefits to the host country or the two countries' investment corporation. So if Indonesian, as I'll show you later if I kind of move on, go back and forth here. Here, if you just move a little bit, go on, and I'll ask you to stop. Go on. So that they can, go on, move, because I just want to show them the example so that
Okay.
Yeah, go on. Yeah, next. Yeah, next. Yeah. So here you can see an example of bid. This is an Indonesian bid. You can see the agreement between the government of the Republic of Indonesia and the government of the Republic of Singapore. Okay, so this is an agreement. As I said, treaties are agreement. So this agreement is made in 2018. Okay, between Indonesian government and Singapore government. Yeah, it is a bilateral investment treaty. And if you look into the government of the Republic of Indonesia, say this, recognizing that the creation of a business-friendly environment will be conducive and its stimulation of business initiative for greater investment between the parties. So these kind of treaties are made only for the purpose of investment. Means so that two governments come together, and they make an agreement that whatever investments your country is making in my country, I will give them certain protections, guarantees, privileges, benefits, concession. Okay. Similarly, when Indonesian corporations or companies are going to invest in Singapore, the Singapore government will also give certain guarantees, promises, privileges, concessions, all these things. So, and therefore, two countries came together and they made an agreement, a treaty. And that treaty becomes a part of international law because treaty is an international law, it's source of international, right? So you can see here that how the private and the public, they come together in the area of international investment law. And the dispute, when there's a dispute between two corporations, so corporations are making, so a Singapore company or a corporation or a foreign investor is making investment in Indonesia, and a dispute arises, right? The Singapore company will invoke bid that this is the agreement two countries have created. They have entered into this kind of agreement, and therefore the dispute will be resolved as per the bid. This particular bilateral investment treaties, okay? And another interesting fact is that this kind of treaties also contain a chapter or some provisions regarding dispute settlement, how the dispute should be resolved, which forum should be the appropriate forum in terms of dispute settlement, whether it's the ICSID or PCA, Permanent Court of Arbitration, or is it UNCITRAL? Okay, so the choice of forum can also be mentioned or included in these bids, okay, in this agreement. So the government has already agreed that any disputes that arise between foreign investor and an Indonesian company, that dispute will go to ICSID. That's it. So all disputes now go to ICSID, depending on some governments, they keep it later, that it would be decided later. Or the recent trend is that many governments are, Indonesian government, as I said, that in the past few years reviewed all its bilateral investment treaties. And treaties also have a lifeline, timeline when they can become expired. So the Indonesian government has decided not to renew a number of bilateral investment treaties and reviewing these treaties because the Indonesian government has realized these treaties are tilted. Means these treaties which have been entered, in the past 15, 20 years, they are giving too much benefits, too much privileges to the foreign investors, and that's why the disputes. Okay, because these investors are taking the Indonesian government to ICSID and claiming $1 billion disputes, awards, right? So Indonesian government has realized that we are giving too much to these investors. We need to keep the agreements should be more balanced, not giving too much. Also, host country government must also have certain rights and certain privileges. Okay, so the government is renewing, not renewing some of these treaties. They are making new treaties, and that's why the treaty that I just shown you, it came in 2018. It's a very new treaty. Okay, and the previous treaty has been terminated because those treaties government realize are kind of imbalanced. They are not equal in terms of rights and obligations. Too many rights to the foreign investors and too many obligations on the host country government, and therefore they are imbalanced, giving too much. Now, recent trend in the dispute settlement is that many governments are now realizing that disputes should be settled in the domestic court, not in foreign institution or international organization. All disputes should be settled in the domestic courts. Now you can argue that whether that will create an investor-friendly environment or not, that might discourage the foreign investors. That is an arguable question. Okay? So you can think about it later. Can I go back? Yeah, go back. Yeah. Yeah, a little bit more. Yeah, more. Yeah, more. Yeah, more. One more. Yeah. So now there are a few other cases, but you can read them later in disputes. You can read them later. I'll share the result. Now coming back to the legal framework. So as I said, there are three legal frameworks. And with these three legal frameworks, what you find here, three interested parties. The host country, means let's say Indonesia is inviting more investment into the country. So Indonesia becomes a host country. Okay? And let's say Singapore, as I have just shown you, the Indonesia-Singapore bids. Okay? If a Singapore company is investing in Indonesia, that company becomes the foreign investor, and Singapore becomes the sending country. Okay, so there are three interested parties. All are interested because Indonesia wants more investment because it will contribute to the economy. Foreign investors want to invest because it will it will be a very profitable business for them. The sending country, the home state of the investor, Singapore, it is also interested because they know that if a Singapore company invests in Indonesia, that will bring a lot of foreign currency, the profit that will go back to Singapore. Okay, and ultimately that profit which goes back to Singapore contributes to Singapore's economy. Okay, so all are interested. They are all interested in international investment. Okay. Now they have a common interest. What is common interest? International investment. So let's say, for example, we give an example. Indian government is encouraging Indian companies, multinational companies, to invest in other countries because the Indian government knows that all the profit the company makes abroad, all those profit will go back to India, and that will contribute to the Indian economy. Okay, so they have a common interest, international investment, and therefore, since there are three parties, there are three laws. Okay, so the host country is more interested in domestic law, contract law, company corporate law, tax law. Okay. Foreign investor, they are interested in international law because they are a foreign company. They don't want to submit themselves to domestic law only. They are more interested in a more balanced international law because they are aware that international law will give them the more privileges, more rights. Okay. Host country, they're also interested into entering into treaties. That's by entering into a treaty, they can, negotiate, because treaty is also a negotiation, okay? Agreement, a contract, an agreement is a negotiation, okay? A bargain, okay? So they can negotiate with the host country and can make a favorable investment or bilateral investment treaty. And that is beneficial for them, beneficial for their own corporation. So they are all interested, and these three parties, they somehow influence the three laws of international investment. So these three parties, they influence, because laws are also influenced by what people want, what foreign investors want. Okay, so if you look into the bilateral investment treaties before 2015, okay, we call it first generation of bids, first generation treaties. You will see that most of these treaties are more in favor of foreign investors. Because, as I said, every country wants to attract more investment. And in order to attract investment, the government must make it more attractive to the foreign investors, giving concessions, tax exemptions, supply of raw materials in cheap prices, all those things. Okay? But if you look into after 2015, then you will see we call it second generation of bilateral investment treaties. These treaties are very different from the previous first generation. If you read them, in terms of rights, in terms of obligations, in terms of responsibilities, in terms of dispute settlements, and all those things. Okay? But those are up to you whether you are interested to read them in detail. Now, first, you find a national legal framework, as I said, domestic law. Okay. Then you find a contractual legal framework, which is also to some extent depends on the national law, domestic law. Okay. And third is the international law framework. In the international law framework, you find the bids, okay, other international institutions and organizations, customary international law, general principles of international law. Those come within international law, other bilateral, other multilateral treaties like the GATT, General Agreement on Tariffs and Trade, other agreements on like NAFTA, North American Free Trade Agreements. Okay, so all those treaties, customary international law, general principles of international law, they fall within the international legal framework. So when a dispute arises, investment dispute, all these three frameworks, they are present to some extent. As I gave an example in the Indonesian case, contract law, company law, then the bilateral investment treaties, international law. Okay, so three laws, they are come together. Can you move on? Okay, so if you a little bit look into the domestic law, how does domestic law become applicable? Domestic law can be, can be in a different form. It can be more restrictive. It can be more liberal. It can, encourage, if the government wants to encourage foreign investment, then the government will make the domestic law more liberal. So that is encouraging. It can be more restrictive or controlling. If the government wants to, restrict more and more foreign investment, it can be more controlling. So here I have mentioned. So one example is that host country legislation might offer tax exemptions and subsidized factors that is more encouraging. So when government says that, okay, you come to my country and invest and we will give you tax exemptions, that is more encouraging. Okay, government can say, okay, it can control the investments by saying that, okay, how much profit you can take out of my country. Okay, so if the government regulates in that way, then obviously that is more controlling. So domestic legal framework can be controlling, can be more encouraging, depending on what the government wants. It wants to make the country more investor friendly, more attractive, then it will be more encouraging, more liberalizing. If it wants to make a more balanced approach, then not too liberal, not too open, also to some extent also controlled. Because if you give too much freedom, then the foreign investors will do whatever they like. They will drain the country. Okay? So the governments also want to keep some form of control over the foreign investors or over the foreign investment. Okay? Can we move on? Next. Two most important aspects of the national legal framework is a contract, which you already understood, how the contract law plays an important role. Another is a property rights. Okay? Property right is very important for foreign investors, and that property law is very important because I am investing in your country. Let's say $1 billion. I will purchase land. I will invest in factory. I will construct buildings, employ technology, machines, raw materials. So all those are my property because I have invested. These are my money. Okay, and therefore, if my property is not protected, then obviously I am not interested. So I want to see what the Indonesia's property law says about protection of my property, because I'm a foreign investor. I am investing $1 billion. I have purchased land. I have brought expensive machinery, technology from outside. I have I have to provide need a security of my investment, and their property law is very important. Not only that, nowadays, as many of you heard, intellectual property (IPR). Okay, so IPR is also property. Okay, so if I am bringing new technology, advanced technology into Indonesia, that is my intellectual property, patent, trademark, copyrights, right? I also need what kind of intellectual property protection is given to me in Indonesia. If the intellectual property law is very is not strict, it's very it's not really strongly enforced, then I will think twice. Shall I take my advanced technology to Indonesia because it can be counterfeit? Yeah. So I have to think about property rights, physical property rights as well as intellectual property rights. Okay? So these two aspects are very important for foreign investors in terms of when it comes to domestic legal framework. Can you move on? So teaching 11:15. Okay. Yeah. Then next day. Okay, so then comes the contractual legal framework. So you already understood the contractual legal framework. Now, contractual framework depends on the national law. Okay? Because it is a national civil code, which talks about contract law, right? So contract law you will find in the civil code, the set down the rules, in terms of promise, obligations, rights, breach of contract, termination, other types of different types of rules that you find in contract law. Now you also need to look into the private international law. So since these contracts or agreements between foreign investor and the host country government or host country corporation is a kind of cross-border contract, so private international law also become applicable, okay, in terms of contract law. So you also need to look into the two areas of law: contract law, domestic contract law, national contract law. You also need to look into the private international law mainly the international contract law in the area of private international law. That is again another area of law you need to look into. Can you move on, Nisa? Okay. So there is another case. I have mentioned one case here, and this case gives an example how contract law or corporate law, contractual framework plays an important role. So this is a case of Kehinde versus Register of Companies. It's a I think Kenyan case. Is a bit old case, 1979. So if you look into this case and read it carefully, you will see that the countries, in terms of the national law, which says that a foreign investor can invest in Kenya, however, in a joint venture company. However, the shareholding should be 70-30. Okay, so the Kenyan corporations will own 70% of the shares, and foreign investors can only own 30% of the shares. Okay, so that you can see that giving more control to the domestic companies, domestic corporations. However, the government made another law, which is a Kenyan company law. The company law says that yes, that it can be like that, but when it comes to shareholding, then the 70% Kenyan shareholders, they will have 2 shares, 1 vote. Okay, means 2 shareholder, 1 vote. So 70% with 35 votes. Okay, but in case of Japanese who own the 30% shares, they will have 1 vote per share. You see, in case when it comes to Kenyan shareholders, they have 1 vote per 2 share. So 2 shareholders, 1 vote. When it's Japanese foreign investor, they have 1 vote, 1 shareholder. So how they are making the balance? Okay. So even if the Kenyans are holding 70%, the Japanese, when it comes to shareholding, structuring the company, deciding the board of directors, appointing the directors, assistant directors, they have more control. Okay, so the country's law can make that balance in that way. Contract law more restrictive, company law more liberal, giving foreign investor more control. Right? Contract law gives more control to the domestic shareholders, domestic investors. Company law gives more freedom, more control to the Japanese investors. So a country's law can be both in terms of making balance between the 2 investors. Okay, you can read the case later. Can you move on, Lisa? Okay, move on. Move on. Yeah, move on. Okay. So here you see I have mentioned, types of contracts that can be made. So sometimes in a state contracts, okay? So state contracts, it can be insurance contracts. So the foreign investor makes a lot of contracts, different types of contracts. First of all, the company's articles of association, okay? A contract or agreement under the corporate law. Then the company also needs insurance. As I say, I'm investing, so I need some kind of protection. So I will buy insurance to protect my property. So insurance contracts. Then I need a loan. Okay, loan from banks. So I need to enter into a loan agreements with bank. I also need to make contracts with the government. Supplying services to government enterprises, entities. Okay. supply of raw materials, long-term contracts with other companies, in the equipment, technologies. So I exchanged a large number of different types of contracts. Okay, the insurance contracts, long-term supply contracts, state contracts, agreements in terms of incorporating a joint venture company. So different types of contracts can be entered. All this comes within the contractual framework. I can have also contract with tax concession contract with the government. The government will give me concession in terms of paying the taxes. That is also another types of contract. So different types of contract I have mentioned here that also become a subject matter of the investment dispute. So whenever there is a dispute, it can be dispute regarding a tax concession contract. Okay, and that is you need to look into the specific contract document. As contract is a source of law. I hope that you have studied in the private law when you studied contract law. A party agreement, a contract document is itself a source of law. Whenever there is a breach of contract, where you need to look into the contract document. That what the parties agreed, what are the rights and obligations that is in the contract document. Okay, so that is the contractual problem. Can you move on the last one? Last part. The last part. Okay.
The last one?
No, move.
Oh, so
I said last part. Okay, go on. Yeah, international legal framework. So I'll do another 2-3 minutes in terms of international.
okay.
So last part is the international legal framework. And within the international law, first of all, you find different, international, as I said, customary international law, general principles of law, and different other treaties, conventions, protocols, okay, those international laws. International legal institutions, as I said, a number of international organizations also play a very important role in the area of international investment, like the IMF, okay, like the GATT, General Agreement on Tariffs and Trade, which regulates world trade. So many agreements or many investment also depend on these GATT rules when it comes to trade agreements, trade concessions in terms of supplying goods, okay. So that also depend on a number of international agreements. Lisa, can you move the next one? Okay. So one of the area of international, as I said, BITs, bilateral investment treaties, they are also a part of international law. So whenever there is a dispute, as I gave example of some of the Indonesian disputes, investment disputes, they invoke Indonesia UK BITs 1976. So BIT is a part of international law, comes within the international legal framework. So whenever there's an investment dispute, you also need to look into where that claim arises. And the interesting thing is that most of the rights, obligations, responsibilities, privileges are actually given or actually mentioned in the BITs. Okay, so wherever there is an investment dispute, the dispute always goes back to very specific BIT, the bilateral investment treaties. They are treaty, they are international law that comes within international legal framework. The last point. Okay, international law also creates international organizations, as I said, right? So SID, okay, there's a building you will find. It is an organ functions under the World Bank, and it also has a kind of organizational structure. Okay, so it settles or most of the investment disputes actually go to the ICSID. Other international organizations you will find the World Bank. Other treaties you will find, for example, the NAFTA, North American Free Trade Agreements. You will also be interested in Energy Charter Treaty. And there are many other treaties, whether bilateral treaties, multilateral treaties, whether, nowadays, regional treaties, okay? Like RCEP, regional, economic cooperation. So there are many treaties nowadays at the regional level that can also become a subject matter of an investment dispute. And all those types of treaties, organizations, international organizations, international institutions, they come within the international legal framework, whether PC, the Permanent Court of Arbitration, UNCITRAL, all they come within the international legal framework. So what we find is that when it comes to investment disputes, three legal frameworks, they come together and they are always involved in one dispute. Okay? So in the end, I'll stop here. And in the end, you will find that I have mentioned certain rules. Okay, these rules. Yeah. No, move on. I just want to show them. Move on. Move on. Okay, so there are applicable laws which you can read yourself. So a number of rules actually develop. These rules are developed from case laws, means disputes or awards given by arbitral tribunals. Okay. So when it comes to which law will apply, so you are more interested to know that whenever there is a dispute, which law will apply. Okay, that's the question. Okay, so when it comes to applying the law, a number of rules. These are informal rules, not any hard rules. So if you read all the different investment disputes, award given by tribunal, you will identify these rules. Okay, so these rules actually apply when it comes to deciding which law will become in a particular situation. So whenever a particular situation, particular issue, a dispute, you can immediately know, okay, this is the issue. So for example, when it is when the dispute, investment dispute comes from the breach of a contract, then what law will apply? The contract law, tort law, company law from the domestic national law and the private international law. Okay? So that is how the rules actually develop. You can read them. So I have kind of mentioned, I think 12 rules. And these rules you will find if you read them cases. So kind of evolved, concrete rules. Okay, so you can think about these rules in terms of when the dispute is this particular rule will apply. That is how the laws are applied. Okay, so that's, I think, gave you some idea, not everything. Because one and a half hour I cannot discuss everything. Okay, so in terms of domestic law, international law, in investment disputes, what laws become or what laws are involved in international investment disputes. That's a kind of the idea. Let's stop.
So there's the end of the presentations. So I think one who have a questions. Anyone?
Yeah,
okay. I will be 3.
12 minutes time to questions.
Yeah, there is 3 people. Any others? 1, 2, 3. Okay. Okay, 4. And the right side and the left side. Any questions? Okay. I will be choosing document.
Thanks for the so I want okay.
Yeah, after you.
Okay. So I want to ask about the topic is about international legal framework that you said that international legal framework work is important for international Indonesian investment. So can I know what is the implementation in international investment? Okay. Maybe.
So your question is that when it comes to international law, when it comes to international legal framework, how we are implemented, right? So what happens is that one of the most important aspects of the international legal framework is the bilateral investment treaty. So as I said, this bilateral is called bilateral.
Bilateral.
Yeah, I hope you understand the meaning of bilateral.
Bilateral.
All you understand, right? Bilateral. Become bilateral. Bilateral is 2 parties.
2 parties have an agreement or something.
So it's an agreement between, let's say, Indonesia and Singapore. So it is a bilateral agreement. As long as both parties are willing to follow it, willing to kind of, make it or make it force, it is applicable. So it depends between the two governments. As long as Indonesian government and the Singaporean government they agree, they said okay, they enter into the beach, they signed the agreement, and they clearly mentioned that this beach will come into force on a particular day and time. That's it. It is enforced.
Okay, thank you.
Yeah, and another is that, so I have mentioned some other treaties, like energy, or ICSID convention, for example. Now, what happens is that in some ICSID convention, okay, the parties or the countries must have ratified. So, as you know, it is an international treaty, it's international convention. The usual rule of ratification applies, signature ratification. So if the country does not ratify the ICSID convention, then it is not applicable. Okay? So the countries must ratify an international treaty, because bilateral is between two. Okay? And other treaties like the Energy Charter Treaty, which is a multilateral treaty. GATT is a multilateral treaty. Multilateral means a large number of countries. ICSID convention is a multilateral, so countries must ratify. Okay, if a country does not ratify, then that treaty is not applicable. So recently there is a debate in Indonesia that many scholars in Indonesia have argued that Indonesia should withdraw from ICSID because it is a neoliberal organization. Most of the decisions are given in favor of foreign investors. So why should Indonesia become part of it? So there is a procedure in the ICSID Article 1, and a country can notify the ICSID, the International Center for Investment Disputes, and say that I want to withdraw from the convention. If it withdraws, then the treaty, the convention does not apply anymore. Hence, investment disputes will not automatically go to the ICSID, and the countries can decide where they want to take their dispute, whether it is unsecured or whatever.
Okay, thank you, sir, for the answer. I already understand. Thank you.
Any others? Maybe we move on, the men. Yeah.
Okay, good morning, Professor. My name is Ruskananda. I would like to pose a question related to the topic. I'm interested understanding more deeply about the limits of state sovereignty in the context international investment agreements specifically. I would like to ask to what extent can principal state sovereignty if the limit by international investment agreement, and how we can balance a state right regulates with the need for a legal century for investor.
So you need to say that how, your question is that how international investment law or investment treaties that will affect the state sovereignty?
Yes, like that.
The most debatable question in the area of investment law. And that debate is going on for the past 40 years. No clear answer. Okay, so I will answer in a way. It depends on the government statute. Okay, it does apply, everywhere. So, let me give a very different example. What countries go to join UN? Right? The United Nations, which is an international organization, like intergovernmental, right? I think almost almost all countries in the world, they are member of the UN, right? United Nations. Now the question is that countries, all countries or governments, they suddenly think that they are going to get some benefits by becoming member of the UN, right? And it might not benefit. It might, so becoming a member of the UN also imposes responsibilities, obligations, right? And human rights obligations, protect human rights inside your country, submit country reports, more scrutiny by the international organization, international community. But still, countries go there, right? Still, so let's say Indonesia is a member of the UN, and Indonesia needs to submit periodic human rights, reports to the UN. Or international community can scrutinize, okay, you are not protecting the rights of people. For example, what is happening in Bangladesh, for example, right? Many of you read news, student protest, and the government is, dealing with these students very high-handedly, right? Arresting them, beating them, right? And that becomes an international human rights issue, right? So the UN or international communities, other countries can ask Bangladesh, oh, well, you are not protecting the human rights of your students, right? Question, international, question. But still, Bangladesh cannot say, oh, okay, I'm leaving UN, right? It cannot say it, right? It will not say, because countries realize that there are also benefits of becoming a member of the UN. Not only that, countries always want to project themselves at the international stage that I am a member of the UN, right? International community showing to the international community that Bangladesh is a very progressive country. It respects human rights, and therefore it has become a member of the UN, right? So in the international investment law, countries always want to show that they are interested friendly. We want to, we are inviting, people, come our country invest. We are going to see a lot of concessions, subsidies, loans in very low interest, what is called foreign currency convertibility. You can take much of your profit, entire profit out of the country, no restriction. So countries always want to project themselves as a investor friendly, bringing more investment. However, it has a cost, right? But so let's say one of the largest company, foreign investor in Indonesia, I think makes a profit $5 billion. I see that the company takes that $5 billion profit out of the country immediately. It can create a foreign currency crisis, but that's how it is. It has a cost. Right. So it's a now, yeah, sure.
So yeah, to add to Dr. Mizanur's opinion on the sovereign's behavior, if I may, right? So we can take the most recent example. Yeah, we can take the most recent example on the new capital, right? So IKN or Ibu Kota Nasional, right, in Borneo. So I just got the update, I think the news like a month ago, that the Indonesian government gave at least 9 different tax incentives to any investor that would like to invest in IKN. And the lease, I think, for 120 years for the land lease. So that is one government behavior. And we, the Indonesians, know the future based on the studies that has been shown and from NGOs, even the McKinsey, that the future of this IKN is rather gloomy. And we have to attach this with whose regime that is running this current country at the moment. And when the regime changes, the behavior might shift. Even currently, if you look the updates on whether this newly elected president is slightly reluctant in continuing this project, because the regime will change by the last quarter of this year, I think by October, right? The swearing in of the new president. So after understanding this concept that has been taught by Dr. Mizanur and apply this to the current trend that we have, right? Then you will have clear perspective. These are the possibilities that might arise. If this is a newly elected president who would like to shift its perspective, all right, let's defer this project. How about those investors that already invested millions or billions of US dollars, right? Because this new, we will see how it looks like this August, because like our current presidents would devote themselves to have the 7th of August ceremony in this new capital. We will see how many bridges, how many houses, whether the presidential palace is already running or some ministries building already built up. So yeah, I think that's it. Thank you.
I just want to add one more very important point here. Sometimes we think about law very isolated in a very isolated way. So international law is also a part of international politics, international relations, and they are linked. Okay. So what happens is that sometimes the governments are in a very complex position, in a very complicated situation. Okay, because Akmal just mentioned that we have a previous government or an existing political regime, and government's behavior or attitude or decision can change when it changes, right? However, I will kind of I'm going to briefly mention that I have mentioned insurance contracts. Now, in the area of international investment law, political risk insurance is a big business. Okay? And political risk, what is political risk insurance? So if foreign investors suffer loss because of political change, okay? So one previous or existing government has entered into a contract agreements with foreign investors, and this investment is also covered under a political risk insurance. Okay, so there are many international companies, international organizations. They cover the investment for political risk. And political risk means regime change. Okay, so if a new government comes in and makes a different decision, let's say canceling the concession contract or completely canceling the project, those kind of cancellation will be covered under the political risk insurance. Okay, and that can lead to a dispute, because dispute not just against the government, but against the risk insurance companies. There's a contract, right? So the government sometimes are in a very complicated position, not just when one government in a very poor economic shape. The country is in a poor economic shape. Government do not have the funds, right? Do not have the enough revenue generation. It needs fund from anywhere to to pay for the public services, right? Water, electricity, keeping the price low, healthcare, education, but government needs the money. If the government fails to create new industry, new infrastructure, means no new jobs. So public opinion, public attitude will go against the government. So government needs to run the cycle. Okay? And in order to running in the cycle, they put themselves in a complicated position. Okay, because they have no escape. Because if they fail, they lose in the election. So they need to run. They need to keep running. They need to run the show. Okay, and in order to run the show, they go to World Bank. They liberalize, inviting more and more foreign investors. Come, invest in our country. We will give you concession, in the hope that it will generate employment. But they don't realize that they're actually putting themselves in a debt trap, because they ultimately fail to repay. I give an example of Sri Lanka failed to repay the Chinese debt, and they gave their own port to China for 99 years of lease, giving one entire port to China. That okay, we are unable to repay, take this port and do whatever you want. Whatever profit you can make out of it. So you can see, and long-term land agreements, unable to repay, give us 100 acres of land on lease. Now foreign investors are bringing their own farmers, own technology, everything, and making profit, generating whatever they can do. So it's a very complex, government sometimes in a very complex position. They don't have any escape, okay? Because they need to run the show. They need to show that I am doing everything I can. But when they lose the election, then everything has become clear. Oh, okay, this amount of debt now. Who is going to pay? Yeah.
All right. All is clear. Okay. Will you remove the woman? Please tell your names and if you want questions. Yeah.
Good morning, sir. My name is Andrina. I hope you don't mind approaching you with a question about Indonesian investment legal framework. I'm particularly interested in your expert perspective on this matter. So I would like to ask, with your expert opinion or even your perspective, what are the main strengths and weaknesses of Indonesia's current legal framework for handling investment disputes? Thank you.
Okay. What I would say is that, I gave a statistic, show the statistic that previously very few countries were actually, host country governments are winning or getting these, investment, disputes. But the trend has slightly changed. Now you see, if you, as per one detail, Indonesian government was involved in 7 disputes. According to another, information, it is 12, not 7, but 12. And if interesting thing is that what I found very interesting that many of these disputes, the Indonesian government actually own these disputes. Okay, so the trend is slowly changing, and you can say, Akmal will say, the third world 12. So third world, the emergence of third world in the international law, or the emergence of, or maybe we can say reinvention of the third world in international, legal picture or in a legal state, okay, in the stage of international law. The third worlds are contesting. So if international investment law is tilted, is imbalanced, giving more to foreign investors, now the third world is now contesting that, contesting that idea, contesting that, Euro-American idea of giving more protection, more privileges. The colonial, during the colonial period, the colonizers, the colonizing, that their corporations, what they did, whatever they wanted. They got whatever privileges they wanted. Now, third world is contesting. So interesting fact is that Indonesia actually own most of these disputes. Another interesting fact is that, as I said, that I think from 2015, a new trend has kind of emerged that many of these developing countries are actually reviewing their bids, means, canceling the earlier bids, okay? And they are renewing, they are reviewing. So India did, Indonesia did, Brazil did, South Africa did, even some of the European countries, Netherlands, they have revised their bids. They have cancelled the old bids because, they realize that these bids are imbalanced. They have given too much to these investors. Okay? Now they are making it more balanced. Okay, so it is more about balancing the rights and obligations. So previously, more rights to the foreign investors, more obligations of the host country. Now, equal. You have rights, you have obligations. I have rights, I have obligations. Okay. And one of the interesting things, the recent trend is that many of these countries are saying, including in the bids, that these investment disputes should be settled first by the domestic courts. Second, if the domestic courts fail to settle the disputes, then through diplomatic negotiation, not the ICSID, not any international tribunal. If you want to, very specific example, read the Brazil model bid, even the Indian model bid. It talks about that no more ICSID, no more PCA, no more ANCITRAL. First, go to domestic court. If we fail, diplomatic negotiation. We can settle the dispute through diplomatic communication. Because when it goes to ICSID, huge claim, billions of dollars of claim, and the dispute settlement became a profit-making industry. Third-party funding, choosing your own arbitrators who is more favorable to foreign investors than choosing that kind of arbitrators. So it's a whole ball game altogether. Yeah. So I think the countries are, third world countries, they are waking up. They started changing their perspectives. They're contesting this Euro-American narrative of giving more privileges, rights to the foreign investors, and third world countries are simply that taking the bond, in the name of development, in the name of contribution to the economy. So they are waking up, they're challenging, they're contesting. So the perspectives, the thinking has changed, and that thinking is reflected in the new second generation of BIDs. The BIDs, which came after 2015. I showed the Singapore BIDs. If you look into the new BIDs like India, entered with Brazil, some other countries. They're very interesting BIDs. If you read them, they're very interesting, especially the dispute settlement provisions. They're very interesting, actually, even including corruption. Previously, the interesting, previously, if you look into some of the BIDs, corruption was not an issue for investors, but some of these investment disputes, if you read them carefully, foreign investors got their contract or made the investment through corruption, giving bribe to the governments in Africa, right? So corruption was never really. So the new government came into power, and the new government realized the previous government actually took a huge bribe and gave, let's say, a mining contract, which is the natural resource exploitation contract, right? Now the new government want to cancel. No, the previous government took a bribe and gave you the contract. We want to cancel it. But if as I said, if cancel, then dispute. Go to ICSID. Okay. Now, what happens that previously corruption was not a ground for a claim that a host country can bring against a foreign investor. But if we look at the new generation of BIDs, after 2015, corruption has been included. Now, corruption, if a foreign investor makes an investment through corruption, that can be a ground for challenging or bringing a claim against the foreign investor. So changing dynamics in the BIDs, how the BIDs are drafted now. So that's how how thinking has changed, narrative has changed, ways of lawmaking also changed in 2015 onwards. Yeah. So yeah.
Questions? Here, Shifa. Okay. Bagaimana? This is the end of question. Go on.
Yeah.
First of all, thank you so much, sir, for giving me an opportunity. First of all, I would like to introduce myself. My name is Shiva Sofia Galeni. Here I want to ask about the applicable laws that in the point 6, there are whether a legal entity has the capacity to prosecute. How we know that maybe there are one problems for the contract that one of them is have a different national laws and becoming a problems between their contract. How we provided that issues? Thank you.
So as I mentioned here, the in terms of coming to a capacity to prosecute. So what we call in a law, I don't know, in civil law country probably the concept is different. What do you call locus standi in common law? Is it different? Same. So we know we generally talk about a legal concept called locus standi. Means who has the standing. Means who has the legal right to bring a claim. Okay. So that is the capacity to prosecute. Now, I have mentioned here, investment treaty tribunal is a lex societas. Okay, so what is lex societas is that there are two approaches. One is called the seat of the corporation. Okay, and there is two approach. One is called the statutory seat and the real seat. Means real seat means the real nationality of the foreign investor. So if the nationality of the foreign investor is Singapore, then the law of the Singapore, under the law of the Singapore, whether the foreign investor has the capacity to prosecute, it can be the statutory seat. Means that statutorily, if let's say the foreign investor has incorporated a company in Indonesia under the Indonesian corporate law, then it is a statutory entity, a juridical person, right? So under the Indonesian corporate law, the company, the foreign investor, gets the local standing because it is within the jurisdiction of the Indonesian law. Okay. Now then the question arises: does the Indonesian law gives the right to the foreign investor to bring a case against the host country government, like Indonesian government, whether the law permits that? So there are two questions, and that kind of varies. So different country has different approaches. For example, in Germany, a foreign investor cannot bring a case against the host country under the national law. Okay? But if you go to Switzerland, a foreign investor can bring a case against the host country under the domestic law. So different country chooses different approach. It can be the statutory seat, or it can be the real seat, a real nationality. So looking into, depending on which country they are from, the nationality of the how the foreign investor is incorporated. If it is incorporated statutorily in Indonesia, then what the Indonesian law says about it. If it is not incorporated in Indonesia, but the foreign investor made the investment to a joint venture, okay, then it is the investment or the company is not incorporated in Indonesia, but the foreign investor nationality is Singapore. So the real seat might be applicable, depending on how. Now, one of the interesting things is that when it comes to applicable law, it is the arbitral tribunal that decides which law will become applicable. Okay, so that's the ultimately it is the tribunal that decides that which law will become applicable in the dispute, whether the case, the jurisdiction, the admissibility, applicable laws, right to prosecute, whether a host country can bring counterclaims, everything is decided by the tribunal itself.
So, including and additional things that we have. Yeah. It depends on the tribunal.
Yes.
Depends on tribunal, which is where
Sometimes maybe in one country and another country have investment.
Yes.
Which law have governs to if they are chaos or something like the dispute. So which law? In international private law, we learn about the choice of law.
Yeah, choice of law clause. Yes.
Choice of law is the key, the principles. You have to choose the law, which one to choose to govern your disputes.
Yes. Yeah. Sometimes what happens is that, as I mentioned, the contractual framework. Okay.
Yeah,
so as I said that, generally the foreign investors, they enter into a large number of contracts. So in any of those contracts, the foreign investor and the host country government can decide to include a choice of law clause that in case of disputes, which law will be chosen to resolve the disputes. Okay. And then, I will say Indonesia, I'll say Indonesian law because I know Indonesian law. I know the Indonesian law will be favorable to me. The Singapore foreign investor said, no Indonesian law. I want, Singapore law. Okay. Then argument, they say, okay, let's decide. No Indonesian law, no Singapore law.
So
let's say English law. They can decide. Okay. Now, many agreements, what happens is that sometimes they forget, or sometimes they keep it for later. Okay, that no choice of law clause is included. right? In that case, what happens is that it is the seat of the arbitration. So if the arbitration is in ICSID in New York, if it is in Permanent Court of Arbitration in London, what is the Singapore Center for Arbitration, that law becomes applicable.
Okay, you got it? Okay, maybe this is the last question from our student because this time is out.
That's okay, fine, no problem.
They have a next midterm examination, so they have to take a rest, maybe 30 minutes. After that, they have to continue. Maybe some students have beberapa mahasiswa ada yang mau mengikuti ujian kan di 12.30. Ada atau diada-adakan? Okay. Okay, that's okay. So may I speak Indonesia to my students. Jadi yang kelasnya Bu Anissa, saya sudah nge-share G-formnya ya. Oke, G-formnya sama Komting, tolong diisi. Untuk kehadirannya, I will be check yang di agenda USU. Yang saya share juga. Untuk kelas saya, mana nih yang kelas saya? Untuk beberapa kelas saya, untuk tugas tolong nanti di-upload di G-form. Nanti saya share juga. Yang ini, yang tugas hari ini. Kita akan ketemu di Zoom meeting lagi. Oke? Dah, itu aja. Mungkin selanjutnya akan dibawa sama Prof. Setianoto ya. Minggu depan sama Prof. Setianoto, bukan di saya lagi. Jadi change. Before we end, we can take a picture. Okay, I will be paused. Oke, mungkin dosennya akan berdiri di sini. Kalian berdiri boleh, silakan. Mungkin berdiri. To all the students, kita akan take picture. Boleh berdiri? Oke. Enjoy your class.